Good morning all. We're here for a hearing in the matter of CA-011-2019 before the Chief Justice Zaki Azmi, His Excellency Justice Ali Madhani, and His Excellency Justice Shamlan Sawalehi. The claimant is represented by Obaid Almaazmi law firm. Lead counsel is Michael Patchett Joyce. The defendant is represented by McKenzie. Lead counsel is Mazin Bustani.
Who's going to start? Appellant? Yes.
Your Honours, indeed. I appear on behalf of the appellant. I'm assisted by my friend Mr. Antoine Bashara, and the respondents are represented, as you've heard, by my friend Mr. Bustani and by Mr. Max, who's assisted by Mr. Maxim. Your Honours, the matter before the court concerns an appeal against...
Now, before you commence, who filed in this appeal notice?
The appeal notice was filed by Mr. Bashara on behalf.
This is what the appeal notice reads, and it caused me a lot of confusion because I'm trying to read this 6,000 miles away from Dubai. Pursuant to 44.9, the appellant makes this appeal seeking permission to appeal. Seeking permission to appeal an order issued by Justice Omar Al-Mahari. Is it appeal or permission to appeal?
Well, Your Honours, that is a question that I raised as well.
So he's your solicitor.
As I understand it, and there is a measure of confusion, I think we can resolve the confusion. But first of all, Your Honour, I accept Your Honour's point. And I raised this because, of course, within the appeal bundle, there is the further order of the 12th of September, which grants permission to appeal. So if Your Honours turn on to document 6 in this bundle.
I know you're going to say that permission has already been granted there.
Well,
but counsel, please don't leave clerks to do these things for you. The problem is you leave your clerk to do it for you. The clerk doesn't understand the law.
Well,
this does not happen in your country. In the DIFC, it happens in our country as well. In Malaysia, we strike off, dismiss. I dismiss the claim. You go and file another one.
Behind tab 7. Behind tab 7.
Yeah. And then you look at the submission. I think even the submission mentions something like that as well. So it's very confusing to me. Trying to read from the never mind, just go ahead with it. Don't waste your time.
I can.
But this is I think lawyers must be professional in their work. Problem is not enough professionalism.
I can but apologise for the confusion.
And there was no application to even say correction being done before today. Not done so. You discovered. Somebody should have said, apologize, this is wrongly worded. None. Okay, done. Go ahead. I'm not English, I don't speak like English. I'm not diplomatic. I say what I say.
Well,
thank you very much.
As I've indicated to the court, when I read the papers for the first time, it was the first question that I raised.
Then you should have sent in a correction.
Well,
then I don't waste my time. Okay, go on.
Well, I'm obliged. Well, the matter concerns an appeal against an immediate judgment order made by His Excellency Justice Omar Al-Mahari on the 16th of July 2019, which, for ease of reference, has been, and I think during the course of this hearing will be referred to, as the 16th of July 2019 order. As we've just covered, Your Honours, the matter came before the learned judge
Can we cut that thing straight? Default judgment was entered when?
On the 16th of July.
16th of July. Default judgment entered on 16th July 2019.
19.
Application was set aside
On the 12th of September.
12th of
12th of September.
September
2000.
2018. And then Omar refused to set aside.
He granted permission.
Permission.
He granted permission.
No, the application to set aside the judgment. Judgment was entered into. And then there's application to set aside.
Well,
No,
sorry.
no, Your Honor.
Your Honor, there is a chronology. Yesterday, the sequence of events is that I was instructed on Thursday of last week. So
You should not have accepted the brief.
I'm here to assist the court.
Okay.
And between Thursday of last week and today, what I have done is drawn up two documents which were served yesterday and filed yesterday with the court. The first is...
Can I have a copy of it? Where is it?
A skeleton argument.
Where is it?
It has been submitted. It was submitted yesterday.
Behind tab 4.
Huh?
Behind tab 4.
I saw only this morning. Yesterday I was in Dhaka. Okay, let's refer to that quickly.
And Your Honor, the other document that I submitted is a chronology. It's a two-page chronology, and this may help Your Honor's pen in relation to the sequence of events.
Yes.
May I take, does Your Honor have the chronology?
Yeah.
And Your Honor can see that the chronology begins in December 2015. This is history and background.
Yeah.
But on the
2017.
on the
Default judgment was entered.
yes.
Yes. And then application to set aside default judgment.
Well, Your Honor, we are
Application to set default judgment granted.
Your Honor,
Application to set aside default judgment, interest of justice. It discovered default judgment had been registered, entered against him. If default. Okay. The default judgment was entered against everybody. But
May I just, I hope, shed light on things, because we must, in my submission, differentiate between a default judgment, which was indeed entered against, as I understand it, all of the defendants on the 29th of October 2017. That you can see the date and the entry of the default judgment is halfway down the first page
yes,
of the chronology.
I saw that.
Your Honours, the default judgment has been set aside, as I understand it, against all defendants.
The default
No.
judgment, no. it
Not
has
all.
been-
All but 2 or 3. Remember, Mr.
Yes,
you have been
this time.
appearing before us.
This is the third
This is
time.
the third time you are
Third
appearing
time
before
I'm
in
appearing
relating to
before
the
you.
same facility agreement.
Yes, this is the third time.
The other lady was
And the
Miss
same-
Wright Miss Wright was appearing on the other side.
Absolutely, and Mr. Farha. And this is not only the third time, but it's the third time that the same arguments have been developed before the courts.
Never mind,
Your Honor.
that's it.
And the same arguments have been rejected.
It's not res judicata, it can be a precedent.
Yeah.
Okay.
Well, Your Honours, with respect to my learned friend, I disagree with what my learned friend has just said. Because if one looks at the chronology, the claimant entered default judgment against the defendants, including against my client, the fourth defendant, the appellant, on the 29th of October 2017.
Yes.
If one goes 4 entries further down on the chronology,
Yes.
a year or slightly more than a year later, my client discovered that the default judgment had been entered against him. On the 13th of November last year, my client applied to set aside the default judgment, which had been entered on the 29th of October, and he supported that by a witness statement, which is in the bundle. On the 19th of November last year, the application to set aside the default judgment was granted. And that has to be the case, Your Honours, because as part of the setting aside of the default judgment, my client was ordered to file and serve a defence within 14 days. Within time, going to the second page of the chronology, my client applied for an extension of time in which to file and serve his defence. Then, because of National Day, the UAE public holiday intervened between the 30th of November last year and the 4th of December last year, and it was doubtless with an eye directed to that public holiday that the application for extension of time to serve the defence was made. At the end of that holiday period, dated the 4th, but with effect from the 5th, my client filed and served a defence. On the 5th of December, i.e. the day following the public holiday, and notwithstanding that a defence had been served by my client, the Claimant Bank saw fit to make a second application for default judgment, arguing that there had been a failure to file a defence in time. Your Honours, that is a manifestly bad point. And unsurprisingly, the claimant's application for the second default judgment was dismissed by this Honourable Court on the 10th of December 2018. Not satisfied with having two default judgments, or two attempts to get default judgment dismissed, the claimant then applied for immediate judgment on the 13th of December 2018. And it is that third application, the claimant having failed in its first two applications, that came before the court on the 16th of July and caused the order against which appeal is brought. But in the meantime, just to complete the picture, on the 16th of December last year, an extension of time was indeed granted retrospectively to the appellant, my client, for filing and serving the defence, which by that time had already been served, but which tied up the loose end of the application of the 27th of November last year. So, for my learned friend to say this is more of the same overlooks the fact that this is the third attempt by the claimant, and insofar as it is more of the same, the claimant failed on its first attempt and it failed on its second attempt. So, Your Honours, we then reach the 16th of July, which is the date of the order against which appeal is brought. Then the second witness statement of my client in support of the appeal notice was dated the 31st of July, that is in the bundle for the court. The appeal notice post-dated the witness statement and was served together with the first
before you proceed on, the second witness statement, the witness statement, what's the purpose of that witness statement? It's very lengthy, I ran through, but what was the purpose of that witness statement?
The second witness statement was in support of the application for appeal to appeal against the 16th of July.
Permission to appeal, to support permission to appeal. To support his application to seek permission to appeal. Is that what it is?
Well, it was a full...
It contains so many things which is irrelevant.
Your Honour, I accept that on the face of an appeal notice seeking permission to appeal...
No. I'm talking about the witness statement. The witness statement goes, what is it was trying to say? I don't know. So what is the witness statement? Can you tell me briefly what the witness statement is meant for? Can you highlight that's the relevant statement that is relevant to your argument today?
Absolutely. And
yes, please.
I have done that in the skeleton argument, which is also before the court. If one goes to the second witness statement, the second witness statement is bundle 4 in the appeal bundle.
Next up.
Right?
Next up to the Quran.
Next, after 5. After 5. Yeah.
And it's very short. I can take your honours through it in its totality.
No, don't read the whole thing, just read the relevant part of it.
Well, paragraph 2, he says and makes it clear that the witness statement is in support of his appeal notice against the order of the 16th
Support
of
of the
July.
appeal notice.
Paragraph 3, he says he had no contemporaneous involvement. Paragraph 5 is relevant, where Mr. Saif, the fourth defendant appellant, says, I became aware of the claim when my lawyer knew by coincidence that there is an enforcement of the relevant default judgment filed against me at Dubai Court.
Dubai court, in Dubai court.
Absolutely,
Okay.
in Dubai Court, because my client only became aware of this when the matter had proceeded all the way through to default judgment and enforcement was being sought in the onshore courts. And that, I'll come back to the chronology to make that aspect good, but that is absolutely clear from the chronology, and it took a year. So, talking indeed about the default judgment against it at the Dubai court, for which we were surprised and searched to find out the subject claim. He then says he's a minor shareholder. He had 3% in the company Fast Telecom. And then continuing with the second paragraph under paragraph 6. Prior to receipt of the relevant default judgment, I had been unaware that a guarantee in favour of the claimant purporting to bear my signature existed. So there he says quite clearly that he was unaware of a guarantee bearing his signature, not until the date of the default judgment, but until receipt of the default judgment. And by reference to the chronology, your honours will see that there is a year's delay between the default judgment having been entered by Mulla and Friends clients and my client becoming aware of it. That is critically important. Without
Discovered
repetition-
his signature was forged only. When was it? I'm writing. I'm writing
the
on my note.
guarantee was entered into on the 21st of November.
No.
It's dated, the document.
He discovered his signature was forged only when was that?
November 2018.
November 2018, okay. Yes.
And then, of course, my client acted very quickly, as Your Honour will see from the chronology. He discovers in early November 2018, he makes an application to set aside the default judgment on the 13th of November 18. That application is granted on the 19th of November 2018. He submits a defence in time, contrary to what the claimant bank says. He then heads off another default judgment on the 5th of application on the 5th of December 2018, which is dismissed on the 10th of December 2018.
Let's get this correct. The first default judgment was set aside.
Yes.
A fresh claim was served on him.
Fresh claim for a default judgment was
And
made.
then another default judgment was entered into.
Well, an application for a default judgment was made on the basis, as I say in the chronology, and that was dismissed.
Default judgment, the second default judgment was dismissed.
Yes.
If it is dismissed, then you go for trial.
Well, that's what we would like to do.
But
yes.
instead, it was given, immediate judgment was given.
Instead,
Immediate judgment is equivalent to something like summary judgment.
Yes.
Summary judgment is.
Yeah.
I'm an old English summary judgment.
I'm
But
happy
it is-
with summary judgment
Yeah,
too.
summary
the test
judgment.
is exactly the same.
So summary judgment was entered into.
A summary judgment was applied for on the 13th of December last year and ended on the 16th of July.
Okay. Summary judgment was entered into. What normally do? Apply to set aside the summary judgment or appeal against it.
Yeah.
Two ways. Either you apply to set aside or you appeal against it. You cannot, in fact, you cannot set aside because the summary judgment was entered in the presence of both parties. So you appeal against the decision of the summary judgment.
And that's why we lodged an appeal notice dated the 4th of August.
So this appeal is against summary judgment.
Yes.
Okay? And permission was given.
Permission was given on the 12th of September.
On 12 September of 2018. 19? So this is what this appeal is all about.
This is what this
So
appeal
appeal is against immediate judgment.
is. It is.
That's what the notice should have said. I would have understood it. What the notice claim form is talking something completely different from what you're submitting today. There's a problem. I'm trying to read from a document 5,000, 6,000 miles away. And I don't have the document. If you had said that from the beginning, life is easier for all of us.
Well, Your Honour, I can...
So now your appeal is against that immediate judgment.
It is, Your Honour.
Okay, now go straight into why the immediate judgment was wrongly entered. Straight. Don't waste your time. Don't go about wobbling on. Just go straight to the point. Why? 1, 2, 3, 4, 5, 6.
Good. I'm obliged. I shall endeavour to do that, Your Honour. And what Your Honour should have, just to make sure that we have the right documentation, Your Honour should have an appeal bundle, and if one looks at the index page, which is the second page to the appeal bundle, it should have documents 1 to 7 listed down the right-hand side.
Well, this is not supposed to be an appeal bundle. It's really just a collection of documents.
It
I
is-
don't know who this is your file?
well, it was submitted at the same time. Yes.
Well,
Yeah. This is what we call a core bundle.
It's
It's
essentially
a core bundle.
Yes.
Do you want to refer to only the documents in this bundle?
Yes, I
Okay,
think
good.
that's all we need to do.
That's what I think so.
Yes, I think that's all we need to do.
Okay.
And you're absolutely right, it is a core bundle. But I wanted to make sure that, so far as the index is concerned,
There is no index.
on the second page,
I don't have index. I have only documents. Okay, there is an index, but where is the pages you are referring to down? To say from what?
well,
From 1 to 7?
Yeah.
It's fine. I find the index. Then which page now you're referring to?
well, I just wanted to, for present purposes,
Yes.
I want to make sure that we are talking about an appeal bundle with where the index talks about documents 1 to 7.
Yes.
Yes,
All right.
understood. We got it here.
Yes. The reason why I'm doing that, Your Honour, is because there may be a different version which is numbered 1 to 8. I just want to make sure that we're on the same, literally on the same page, and we're working off a bundle which has documents 1 to 7. Now, separate and distinct.
Document 1 to 8. I have here 1 to 8.
Yes.
And yours is half a page. You.
This is last night amendment, Mr. Batik.
Yes, it has been amended.
Never mind. Forget about it. Just go to your point. What do you want to raise?
Your Honours, what I would like also to ensure is that you have the respondent's skeleton argument
What is that? What
of the
number?
6th of November.
6 November. No,
Behind
what?
It's not in the bundle because it came after the original appeal bundle. But as long as Your Honours have my learned friend's skeleton, it's very important for equality of arms that Your Honour should have my learned friend's skeleton.
I granted it myself.
Okay, go ahead.
And do you have my skeleton of the 9th of November?
In this bundle, who prepared?
Yes, I think it is in the bundle.
Wait.
I think it becomes...
Excuse me, Mr. Who prepared this bundle?
Mr. Bakara.
Okay, Mr. Bakara, tell me where it is. What, Mr. Patchett? How do I address you? So I can I call you Michael?
You can call me Mr. Michael. Those people do, yes, in this jurisdiction.
Mr. Michael, can you, refer to this instead of leaving Mr. Michael to go about not knowing where it is?
No, I think it's documents 3 and 4.
3 and 4. Okay, 3 and 4. Is your client here, Mr. Antoine?
Saif?
Is your client here? I wish he's here so you can hear what's happening. Okay, next one. A skeleton submission on behalf of the appellant, fourth defendant. Is that what you are referring to?
Yes, and that should say in response.
In response, that's
Yes.
right.
And that is in response to the learned friend's skeleton,
Okay.
which is of the 6th of November. And what I intend to do, Your Honours, is really to put those two documents side by side, because
Don't worry. Just put your case. Let them reply. Don't worry about this reply.
Well-
Let's go to. You have 4 points or 5 points.
Yes.
Let's go one to one. Finish it up. Finish it
Your
up.
Honour, let me then turn to the case in a nutshell.
Yes.
The text, as Your Honours are very well aware, is set out in Rule 4419.
Okay. What does Rule 4419 say?
Rule 4419 is in very familiar terms. It says that permission to appeal may only be given where the lower court or the court of appeal or the appeal court considers that the appeal would have a real prospect of success.
Are we talking about permission to appeal? I thought we are talking about appeal,
Sorry,
not permission to appeal.
Sorry,
That's
my-
another one. That's
my-
another one that's confusing.
My-
The notice says permission to appeal.
My confusion. The text is twofold. Whether, in relation to immediate judgment,
Yes. Whether immediate judgment should be set aside and the matter sent back for full trial.
Yes.
What are the circumstances in which immediate judgment is to be set aside?
yes.
Where does it appear? What rules that? I must admit, I'm very, very unfamiliar with the RDC. I'm used to my old white book, but the numbers are
44,117.
again. Sorry,
44,117.
44,117. 44,117.
Yes. The immediate judgment part is part 24.
24.
Part 24 is immediate judgment, and then appeal is part 44.
Yes. 44.
And then, as my learned friend says,
44, 100.
17.
Forty-four 100. I got only 44 100. I don't have 17.
This is maybe the old
117.
No, this is.
You see,
there are-
this is another thing. Put me a book which is out of date. What's the use?
They have not to provide authority bundle.
Your Honor, there are new and
Have you got an extra copy of that?
This is the old one, Shamlan.
Why did you keep it on the table? Throw it away into the waste basket. And the other thing also, these rules, every time there's an amendment, they are renumbered all over together. There is
Yes.
the general provision for appeal, when it is wrong or unjust because of a serious procedural or other irregularity in the proceedings of the lower court. Okay.
Yes. And then, Your Honour, in my submission, one needs to go back to look at the test for immediate judgment, which is in part 24.
Part 24.
Part 24 and part 24.1.
24 what?
Part
24 point what?
Part 24.1.
Point 1. Okay.
So under Part 24.1, the court may give immediate judgment against a party on the whole or part of the claim if, 1, it considers that the party has no real prospect of succeeding on the claim or issue, or the defendant has no real prospect of successfully defending the claim or issue, and there is no other compelling reason why the case or issue should be disposed of at trial. So the test essentially...
Which one are you relying on?
Well, we say both limbs are
Okay,
satisfied.
can you apply the facts to this and see why there's no prospect? Why there is prospect of succeeding?
Yes, absolutely. Let me explain why we say that both limbs are satisfied. When one looks at the respondent's skeleton argument,
There's no test here, Your Honor. This is not a test.
Again, sorry?
This is not a test, Your Honor. I don't see that this is a test. This was already awarded on the basis of the...
Never mind. You reply when your time comes.
Okay.
Let him... I can intervene. You... So you said immediate judgment was wrongly entered because...
because my client has a real prospect of success.
Okay, what is that prospect? Give me the facts. On the facts, what is that real prospect of success?
Right. There are 4 grounds which we need to cover, but I'm going to focus on one of them.
Okay, that namely?
And the ground that I'm going to focus primarily on can be referred by shorthand as the forgery claim or
okay.
argument.
The forgery. Whose responsibility in common law? Whose responsibility is to prove a fact? Whose responsibility does it lie on?
Well, is the party seeking to
Prove that
establish
fact.
that fact?
Have you adduced any evidence to prove that fact?
We have adduced very slim evidence at the moment. And
What
I
is that?
accept
What is that slim evidence?
that evidence is the evidence of my client saying that it is a forgery. And
Full stop.
well, not quite full stop, if Your Honour will bear with me. Because what my,
should allow him to. This is important.
Okay, let me say.
because what my client did say, and we can go and look at this, is he invited this court to refer the matter to the appropriate Dubai laboratory.
Is it the responsibility of this court to do that? In common law. In common law. Is it the responsibility of this court to do it?
Your Honour, the short answer to Your Honour's point is no.
Of course.
But I need to explain.
Okay.
Because this is...
Admit, I'm going to write that. Admit it is not duty of the court. Okay? Okay, go on.
Well, I think, Mr. Michael, you are allowed to develop the argument you wish to do
Thank you.
in your sequence. So,
Thank you.
go on.
Thank you.
No, and it's not duty of court to refer
Your Honour,
to.
in my submission, what I'm about to say is very important, not only for this case, but for this court. This is an international commercial court which brings together litigants from around the world who may come, like Chief Justice and myself from the common law tradition, may come from a civilian law tradition, like Your Honours who are sitting with Chief Justice. There are differences between the common law approach and the civil law approach. My client has said, confirmed by a statement of truth, that his signature on that guarantee is a forgery. He has also invited this court, which I accept is a common law jurisdiction, to refer the document to the laboratory. Now, I recall the well-spoken phrase of previous Chief Justice Wang, who said that this court is a common law island in a civil law ocean. What my client did when he invited the court to refer the matter to the appropriate laboratory was to not conflate, but I accept confuse the way in which one would go about proof of his case under civil law in an alien and unfamiliar environment to him, which is a common law jurisdiction.
But isn't he
Can I
represent?
finish this point? Right. In the context of an international commercial court, in my submission, what the court should seek to do in administering justice is to distill the core of what any party's argument is. And this comes back, Your Honour, to answering Your Honour's point. Yes, I accept the burden of proof is with my client. Yes, I accept that as matters stand, the evidence is thin because it's only what he says in terms of admissible evidence. But what my client has clearly done is manifested an intention, albeit going about it through the wrong process, but he has manifested an intention to rely on expert evidence in support of his argument that his signature is a forgery. Now, when one reaches that point and stands back, whether one is looking at it from a common law perspective or a civil law perspective, if one has a clear manifestation of an intention to rely on expert evidence, that, in my submission, should be accepted by an international commercial court of the nature of the DIFC courts.
Okay.
And of course, sorry, yes.
Okay, I understand what you're trying to say. Factually, while waiting for the hearing to come in today, why didn't your client send the document to an expert, writing expert, to testify, to produce a certificate, to say he thinks that the signature is forged? Why did he do it up to today? He could have done yesterday, the day before, last week. Then you put me in the, but here, A, B, that signature was attested, wasn't it? On the balance of probabilities. On the balance of probabilities. It is attested by a witness against a person who says it's not my signature. A. B. He didn't take upon himself. If I were his solicitors, I would take straight away, send it to on my own, send it to the expert witness, the handwriting expert, produce a certificate and say that I don't want immediate judgment to be entered against me because I got a certificate from the handwriting expert to say this is forged or possibly is forged. Because the handwriting expert will never say it's forged. At the most he says, I think in my opinion it looks as if it is forged.
And then one would have
something to consider. But now I hear the respondent. Respondent says he's certified here. So one is certified, one says it's no. I'm being very fair to you, Mr. Michael, because I'm throwing to you all that is in my mind now, giving the opportunity for you to make your statement.
CJ, if I may make one point really, I mean, it's It's a very fair point, actually. It's not in favor of anyone, actually. And in this jurisdiction, Chief Justice, I'm speaking about Dubai. It's not easy for someone to refer to any registered expert for double checking a signature and provide a report. Usually, there is authority doing this, which is the police. Police usually do not accept a layman to refer directly to them without an official referral by a certain authority, like a court or public prosecutor. It's not England, it's not United States. Mr. Bustani can correct this. You do go to a normal expert, even if he's independent, and say, would you please attest my signature and provide me a certificate? So I'm denying this is mine. So this is, I'm trying to make a point. I mean, even the claimant himself could correct this, is that right? But I think it's not easy. I mean, there's a point.
But before immediate judgment was entered,
Well, I know there is a point when you raise the point, how you deal with it, how you ask the court to do something for it.
Can I just clarify one important point, Your Honors? Very important point is that the forgery was never raised
Yeah, I
before
understand. This
the
is another
hearing
one.
of the immediate judgment.
Yes.
before immediate judgment, it was not raised.
It was not raised
Okay.
in his written statement of
Okay,
defense.
you have your time, your opportunities to speak.
Thank you, Your Honor.
Yes,
Well,
Mr.
I would like to rebut immediately what my learned friend has just said.
Please.
And in order to do this, I would invite the court to turn up. I think it's either document 5 or document 6, but it is the first witness statement of my client.
When is that? What is that? Which enclosure is that?
I think it's document 6 in your bundle.
First witness statement of Saif al-Saeed, is it?
Yes.
Okay.
You have that, Your Honour.
Okay, next page.
And Your Honour will be assisted by having the chronology in place.
Yes.
Because Your Honour will recall that my client, literally days before he made this first witness statement, became aware of the default judgment. So this witness statement is made hot off the press. It is made immediately. My client became aware of circumstances. He makes it, as one sees at the foot of the first page of his witness statement, in support of my application to set aside the judgment in default. He gives the date of it, 29th of October, top of the next page. Paragraph 3, as explained below, so he elaborates on this main point, I had no contemporaneous involvement in the procedural steps, etc.
I beg your pardon. I've lost you. Where? What paragraph are you referring to
Well,
again?
let me take it a bit more slowly. I've gone on to the top of the second page.
Top of the second page, yes.
And that's the continuation of paragraph 2, so one sees the date of the default judgment, the 29th of October.
Yes.
Then paragraph 3, as explained below, I had no contemporaneous involvement in the procedural steps taken by the claimant, etc. Then I think for present purposes we can go to paragraph 5.
Yes.
The claim form provides an address for service at and it gives an address.
Yes.
This is not and has never been my address. It goes on, at no point did I receive any copy of the claim form or any amendment to it. Then paragraph 6. I became aware of the default judgment a few days ago when my lawyer knew by coincidence that there was an enforcement of a default judgment in the Dubai courts. Paragraph 7, he makes the point that he's a very minor shareholder. But then he goes on in paragraph 7 to say, prior to receipt of the default judgment, I had been unaware that a guarantee in favour of the claimant purporting to bear my signature existed. Now, if one stops there, if someone says, until a few days ago, I didn't even know about a guarantee which purports to bear my signature, he is, of course, putting in issue the suggestion that he has signed a document he had no knowledge about. And that wholly rebuts my learned friend's point.
This was not in the statement of defense.
So, days after my client became aware, he rebuts it. Now, having rebutted my learned friend's point, I need to deal with a couple of points from the bench.
Yeah, but you go on the read the next sentence. Read the next sentence of that paragraph, right? I also note, for record, that part of my existence as a very minor shareholder, the first defendant had expressly released me of my liabilities. What does the meaning of expressly released me? Means I was a guarantor and they have released me.
No, Your Honour. This is the passage that Your Honour has taken me to is, with respect, a completely different point. There are 2 points. One is the point that I'm answering, which is whether my client put in issue that the guarantee was a forgery at any time before July 2019. On the basis of the passage prior to receipt of the default judgment, I had been unaware that a guarantee in favour of the claimant purporting to bear my signature existed,
Yes.
is, in my submission, a full rebuttal of a suggestion that the guarantee had not been put in issue. Fundamentally, prior to July 2019, it had, as we see from this document dated the 13th of November 2018. Now, Your Honour raises a different point. Your Honour raises a point which is the earlier part of paragraph 7, where my client says that he was absolved of all liabilities by the second and third defendant because my client was a minority shareholder. Now, I deal with this again in my skeleton, but let me deal with it now. If someone says, well, I absolve you of all liabilities, that's shorthand for saying I absolve you for such liabilities if any of you have. And it's non-specific. So, if someone comes along and says, well, I absolve you of all liabilities, and you say, well, I'm relying on that absolution of all liabilities, that cannot be taken as acknowledgement of a specific liability. It simply can't be.
I can look it differently.
Well, Your Honour, I will take you to my skeleton, where I hope I've set it out succinctly and comprehensively. It is answered, and I'll take you to the answer if I may.
Yeah.
But before I do that, I need to come back to a further point which has been raised from the bench. As has been, in my submission, completely correctly said, the usual way in which forgery is established in the Emirates jurisdiction is by court reference to a laboratory which is essentially a police laboratory. And therefore the only mechanism for doing so is on court reference. There is no facility for an individual to take matters into their own hands. And because that process is in essence within the wholly public domain of the police, there is no private domain of forensic experts in independent third-party practice, such as one can rely on in England and Wales or in Malaysia.
I reject this, Your Honour. There are a number of...
You will have your opportunity to speak. Don't interrupt, please.
Now, I put it in...
You write down what you want to reply, and we'll hear you later. Okay?
I put it in rather stark terms. Well, I may be right. There may be that there are some private institutions which are emerging to meet market demand. I wouldn't be at all surprised if that were the case. I'm not going to venture into disclosing any...
Okay, let me just...
Well, I'm not going to venture into disclosing any professional advice, but Your Honour can rest assured that coming at this matter with common law eyes, there are steps which seem very straightforward to a common lawyer, which may not seem at all so straightforward to a civilian lawyer.
Yeah,
But in the context of an international commercial court, in my submission, the court must bear with parties to a certain extent, particularly where here the forgery has been clearly raised from the outset, November 2018, as we've just seen in the first witness statement, and where, albeit going about a wrong process, an intention to rely on expert evidence has clearly been manifested. And just to complete this point, if I may take you to paragraph 46 of the Schedule of Reasons to the order of the 16th of July 2019. So I think that that is the last document in your Commonwealth, counting literally 2 pages in from the back.
Yes.
And if I'm right, the 2 pages in from the back should begin with paragraph 46. And paragraph 46 is, if you turn back a few pages, clearly paragraph 46 is the Schedule of Reasons to the order of the 16th of July 2019. Now here, His Excellency Justice Omar Al-Mahari was setting out the criteria for immediate judgment. Criteria for immediate judgment is spelled out in inconvenient form in GFH Capital and David Lawrence Haig, in the judgment of Justice Roger Giles. As these principles are well established, I will not go through them in detail. Yet broadly speaking, the court has to consider whether the defendant has a realistic prospect of success, which carries a certain degree of conviction, rather than being merely arguable. In reaching its conclusion, the court must take into account not only the evidence placed before it, but the evidence that can reasonably be expected at trial. Now, in my submission, we have tied into the exercise that we've just gone through, amply established that the evidence that can reasonably be expected at trial will be evidence, expert evidence, in proper form, going to the issue of forgery.
Okay, give me 2 minutes.
But it can be quick. They ask him to come is true. They ask what you told me to say, he said, we raised to the judge, there is a problem. The judge said, this is a sin difference. But he would continue, he would say, this is the person who didn't say, we raised it by once.
Okay, sorry, I apologize, Mr. McKenzie. Yes, proceed, please.
I'm glad you're. Well, I said there were 4 points, and I've largely covered, from a helicopter perspective, the first point.
Oh, not yet, Mr. Michael, because I would like you to address the point that the way the judge refused to take your argument about forgery. I think you need to address to the court. Because the judge said this is a very last minute argument was put before him. It's only in the trial date. And I think you might need to say something about this.
Yes, Your Honour. Put shortly, we say that no weight, and certainly no sufficient weight, was given at first instance to the evidence which goes back to November 2018 from my client, and that is the evidence that I was just taking you to. In particular, what was said in paragraph 7, where prior to receipt of the default judgment, the fourth defendant says, I had been unaware that a guarantee in favour of the claimant purporting to bear my signature existed.
Well, again, when was this filed? This
It was filed in November 2018.
This was in against the respondent's application for immediate judgment.
No, it was because the application for immediate judgment only saw the light of day in December 2018. This document was filed in response to the default judgment, but it was before the court on the summary or immediate judgment application, because the evidence that my client had given at an earlier stage was relevant.
Yeah, Mr. Michael, because the judge below says this argument was raised for the first time at the hearing before him.
Well,
But you're saying this is wrong, isn't it?
Well,
it's been raised before.
it may have been a new point. Whatever the judge found, one has to go back to the documentary evidence. And what I've done is to go back myself and in submissions take the court back to what my client was saying, not in July 2019, but 8 months earlier, in November 2018.
Was this witness statement, one that you're holding and referring to, referred at the hearing of the application for immediate judgment?
As I understand it, it was, but I wasn't there, so I need to look for correction, for confirmation. Yes, Mr. Bakara confirms it was.
Can I ask this? When the fourth defendant, your client, submit application to set aside a default judgment, what was the ground for that?
The ground on
I don't
which
have a copy of that here, so we can make sure that has been raised in early stage.
we don't. It is available on the court record.
Do you have a copy right now?
And it can be pulled up. My recollection is that it was simply granted with no or very small schedule of reasons.
No, I'm following your argument. You say in November, I guess, 2018, during the enforcement procedure, your client found out for the first time this case against him. So he came to the DIFC court and asked for a default judgment against him. So in that time, when he filed that application, he's supposed to mention that I need this default judgment to be set aside because this is not my signature. Is that the case?
It certainly looks a good case because that was clearly before the court.
We need to see evidence.
Yes.
Where's that?
Well, what we have, I wasn't there, so I can't give evidence. But what we have is we have the default judgment in late October 2018. We have this evidence of the 13th of November. And we know that the application to set aside was granted on the 19th of November with directions for a defence to be filed.
That application was granted for your client because it's granted for everybody. This is the story. Now, for your client has specific reason. Your client, I'm assuming your client raised that in the early stage. This is what you're trying to find.
Yes.
To avoid that, the judge say it has been raised for the first time at the hearing. So you need to show us that your client has raised this point at early stage when he made his application for set aside default.
I can do that, and I need to take it in stages to a certain extent. Your Honour is absolutely right in saying that the default judgment of the 29th of October 2017 has been set aside against all the defendants, but not at one go.
That's fine.
So that, for example, the fifth defendant applied back in November 2017. The third defendant applied in April 2018. The second defendant applied separately.
When they come to notice,
November
when they come to notice, they file.
Yeah. So the reason why I'm labouring that point, Rana, is because each of those applications, although they were all granted, they came up separately. So the application for the fourth defendant to set aside the default judgment stood separate and distinct from the other applications, as I've read the file. And we have the application to set aside on the 13th, backed by the witness statement that we've just been looking at. And then 6 days later, on the 19th, the application to set aside was granted. Now, with directions for service of the defendant. There were, and I'm happy to stand corrected, but I'm absolutely clear in my recollection, but I might be wrong, but I'll check it. Attached to the order setting aside the default judgment, i.e. the 19th of November, there were no schedule of reasons. So all that we can work on is that it was set aside for the reasons set out in this witness statement. So in other words, the default judgment was set aside in part, because there are other reasons elaborated in this witness statement, but was set aside in part because my client was clearly there and then saying, I had no knowledge of this guarantee until a few days ago, which purported to bear my signature 2 years ago.
Okay. I need some clarification. There was a first judgment in default that was set aside. There's a second judgment in default. No.
Well, there was an
application judgment in default which failed.
Yes.
When that failed, then the bank went for immediate judgment.
Immediate. Yes. So the third bite of the cherry on essentially.
Yeah, because
the same material.
Because the defense was not served on time. This is why it's failed. Then they asked for immediate judgment, and the court gave them the immediate judgment.
Well, I think we've got to be a little bit careful about terminology, Your Honour, because the second application was based on the fact that the defence was said not to have been filed in time. But the reason why it wasn't filed in time was because the time that it needed to be filed fell in the middle of a national holiday.
That's fair. That's fair.
And instead of recognising that time is suspended during a holiday, the learned defence clients pursued an application, a second application for default judgment. That was dealt with summarily 5 days after it was made. It was made on the 5th of December, it was dismissed on the 10th.
No, just correct me. No, your client, the fourth defendant, first witness of statement signed on the 13th of November 2018, that was to support application for default judgment. Is that right?
It was to support an application to set aside
To set aside?
the first.
The first one. Okay, so it has been raised earlier.
So, yes,
The
absolutely.
point of not signing this document.
Yes.
Which is in paragraph 6.
And I hope I've made this point clear on the chronology at the foot of the first page. And it's really the anti-penultimate and penultimate entry on that page. So, round about early November 2018, as we've seen in his witness statement, my client discovered the default judgment had been entered through his lawyer.
Yes.
Within days, he then applies to set aside the default judgment and supports that with the witness statement here that you've been looking at. So really, at the first
Opportunity, he raised the forgery issue.
he raised the point.
Okay.
Straight.
Thank you very much.
Yeah.
Before you continue, I need some clarification from Mr. Bostani.
Yes, Your Honour.
Mr. Bostani, please remind me how many guarantors were there in your case?
There were 5 guarantors.
5 guarantors.
Yes.
One guarantor's application to set aside failed
One, yes.
against Miss Wright.
Yes.
So that is left 4.
Yes.
And then after that?
After that, you had so first. So to go back to the chronology, the default judgment was entered into in 29 October 2017.
No, don't worry about it.
Yes.
I just want
So
to know.
Mr.
There were
Hoffman-
5 guarantors.
Yes.
One failed. We refused that's why. In other words, he's responsible for the grant because Ms. Jack couldn't give her defense.
Absolutely.
So
She
we
raised
try-
the same defense. She raised
No,
the
don't worry. Answer my question, Mr. Bostani.
So you have-
There are 4.
Yes,
Out
there
of
are
these
4.
4, what happened?
Yes. So you have Mr. Abu Adas and Mr. Barghouti who have filed a jurisdictional challenge.
Jurisdiction challenge.
Although they were the subject of your court and Sir General Cook's
Yes.
judgment.
Yes.
They filed a jurisdictional challenge.
He was dismissed.
Who's not yet, which is not yet dismissed. We have a hearing on the 20th.
Oh, I see. Okay. The next, the other 2?
The other 2, you have Mr. Mazrouei.
1. And the last one?
And the last one, Mr. Zahran, who never appealed.
Never appeared.
And Mr. Harmoudi been rejected.
And Mr. Harmoudi, you rejected his appeal. This is the subject of the slight appeal.
So there are 2 that is waiting for jurisdictional challenge.
Yes, and those 2 are signatory of the facility agreement that provides for.
Never mind.
Yes.
Don't worry
While
about
the
it. No,
other-
I just want to know. I just want to know whether any case is going for full trial so far. Not yet.
No, none.
Not yet.
because-
Not been determined yet.
Because the only person who has presented a defense and has not raised the forgery allegation in his defense is Mr. Mazrouei.
Well, that is your allegation. He says
That's
otherwise.
not an allegation. That's on the record, Your Honor. That's a statement.
Oh,
of
he has
defense.
filed his defense.
Yes, he filed his statement.
Okay,
of
never mind. Sit
defense
down.
before.
No. We'll see you later. Yes, Mr. Mayor. I'm trying to put a bigger picture of what's happening. I must confess, I had presided in a number of these, but I can't remember. I'm sorry to say so.
Well, Your Honour, it is confusing, and that is part of the reason why we say that it's inappropriate to grant immediate judgment, because this is a complex matter. The claims are interwoven and interrelated. There will, because we're at the very early stage of pleadings, but I would anticipate wouldn't say there will, I will anticipate from my professional position that there will be claims inter se between the defendants, indemnity claims, full contribution claims, matters like that. All of these should, in my submission, be before the court in one go. And that is essentially what Sir Jeremy Cook was saying.
That is what I was thinking as well. Anyway, just go ahead, go. You have disposed your issue on forgery.
Yes, I'd like just to respond to my other friend's submission about my client's statement of defence. It is right that my client did put in a statement of defence, and you've seen the circumstances in which that defence was filed. It was filed at very short notice, pressing urgently against quite an extended public holiday, and he complied with it. So if one is looking at...
So the statement of defence was filed before your witness statement?
No, the statement of defence... well, the statement of defence was filed on the 4th of December.
No. Before your witness statement you are referring, or after?
After.
All this come after the application for immediate judgment,
Yeah.
right?
After the... No, the defence followed on the setting aside of the default judgment.
Yes.
Default judgment October 2017, set aside on the 19th of November 2018. As part of that setting aside, directions that my client file a defence within 14 days.
Okay.
That period of 14 days took us into the national holiday celebrations. At the end of that holiday period, a defence was filed, but it was obviously filed under some circumstances of time.
But you admit in that statement of defence there was no mention of defence of forgery.
Well,
It's just matter of fact, matter of statement.
I need to defer to Mr. Bakara.
I don't
because
have the
the
statement
copy
of
that I
defence.
have has a page missing. I will, on the copy that I have, which when I saw it, realised that there was a page missing, it isn't raised. I will check whether the full defence does raise it. But even if it does not raise it, at two junctures, my client says that he expressly reserves his right to amend and reserves his right.
There is a normal clause that you put in your statement, isn't it? Normal litigation counsel, just put it in just in case it leaves something behind. Normal. I will tell you again what's going on in my mind. I've not decided the case yet, okay? If you, Mr. Michael, somebody produces a document and say, you have agreed to marry me, which is not a fact. What is your immediate defense?
Sorry.
I didn't sign that document. Your immediate defense? I didn't sign that document. I never signed that document. That is your immediate defense.
And that's what was said.
You did not. That's what I'm trying to say.
It was said on the 13th of November. I need to check the full version of the statement of defence because, as I said,
Your counsel is there. He can ask. He can compose.
well, I will ask Mr. Bakara to confirm with the benefit of the full document. I haven't seen the full document, and I'm not going to say.
Well, you should have seen it before.
I should have seen it, and I asked for it over the weekend, and what was sent to me, I saw had a page missing. So I do apologise that I didn't raise this beforehand, but it is literally something I have only just seen. Let us work on the basis.
Okay.
But let us work on the basis that it doesn't raise.
Okay. Yes.
Let's
Yes.
work
Yes.
on
Yes.
that basis. Given that it was in my submission raised in the witness statement of the 13th of November, given that this defence was produced under some time constraints and not, as far as I can see, with the benefit of any input by a lawyer trained in the common law, if from a civilian perspective, not only do the words that I refer to, and I accept in a common law context, they're put there as almost formulaic. But in a civilian law context, if you are reserving your rights to elaborate, and you have already indicated in another document what your position is, in the context of a more inquisitorial process by judges inquiring into the merits, rather than this adversarial umpiring that we have, in my submission, it is not impossible for a lawyer inspired by a civilian law tradition to say, well, it's been covered. It was covered just a few days ago. I'm under time constraints. I'm putting in this reservation. We can move forward on that basis. Now, I accept as a common lawyer that I wouldn't do that. But we are an international court dealing with this synthesis of civilian law approach and common law approach. And in my submission, one must approach it with that idea, that unity of idea, so that one is looking at whether not, as a common lawyer, you would have done this, and yes, I would be rightly criticised, but whether it's right to impose the same measure of criticism with the same draconian consequences if this judgment is not set aside. It stands against my client. The consequences are enormously draconian in circumstances where, yes, I accept from a common law perspective, it might have been done, could have been done better, should have been done better, would have been done better.
Can we move to the next point, please?
Yes, sir.
Thank you.
I said that the forgery was the main argument. There are three further arguments which I will deal with from an overview very quickly. My client relied on clause 1092 of the UAE civil procedure, and it said against me that that's inapplicable. I accept that in the DIFC jurisdiction, the civil and commercial laws of onshore Dubai and the Emirates have been excluded. But if the guarantee is not valid, then one is thrown back, in those circumstances, onto domestic law. And in my submission, in that context, but only in that context, it's relevant to raise.
I'm sorry, I don't follow you. You said that if the guarantee is not valid,
yes,
then it's thrown back to Dubai.
Well, then if the learned friend was seeking to somehow argue that there had been a guarantee by other means, that would not be within the DIFC jurisdiction, because this guarantee, this written document, expressly says that the DIFC court has
So you are assuming?
Yes, if it goes, then it's a sort of, it's a minor point to cover the principal point once the guarantee is gone. That's how I read it. I don't think we need to spend much time on clause 109.
If you succeed in point one, then your client is not party to this.
Correct.
So you cannot go to the second.
That is indeed my view. The next point is the fact that my client was a minority shareholder. It said that that is irrelevant.
You don't have to be a shareholder to become a guarantor.
You have to be a shareholder to be a guarantor. I accept that. But of course, what my client has said, and we've seen this in the evidence, and this goes back to your Honour's point from the earlier paragraph of paragraph 7 in the first witness statement. My client says, well, he was given a blanket release. And as a minority shareholder, if you have only 3% of a company, then it does have the ring of truth, or at least greater likelihood, that the main people behind, the main natural people behind this company would make that sort of blanket absolution violent. So in that context, the minority shareholding lends credence to what my client is saying. And that brings me back to the complexity of the picture, because we're very much in the early stages of the pleas. As I've said, there is no indemnity claimed over between any of the defendants against each other, no contribution claim. But the very fact that my client has already given evidence that he was released from liabilities by the two main natural persons behind Fast Telephone is, in my submission, highly likely. I can say only from my perspective as a lawyer, I would be looking down the line to indemnity and contribution. And it's plainly sensible, convenient, it's a compelling reason why the immediate judgment should be set aside, to have everything dealt with together. Because otherwise, we're going to...
I know what you mean. Yeah, let this be disposed at trial. That's what you're asking.
Exactly.
For. Okay.
Exactly.
Okay, the fourth item.
The fourth point is a jurisdiction point, where it is said that under the facility agreement, which my client was not party to, the dispute resolution clause is a little bit complex, and it seems to provide for the non-exclusive jurisdiction of the DIFC court, but it also covers arbitration. Now, of course, my client wasn't a party to that. My client was only a party to the guarantee. If he were a party at all, the guarantee on its face does provide for the exclusive jurisdiction of the DIFC court, I accept. So what is said is, well, for those who are purely guarantors, said to be only guarantors, those people who are only engaged if they are parties to the guarantee, that they can't borrow this alternative method of dispute resolution from the facility agreement. That is, as I understand it, the argument that some of the defendants, including the fourth defendant, seeks to put forward. Now, I have to say that that argument has been severely questioned by Sir Jeremy Cook, and certainly by Sir Jeremy Cook. I have read that, and I can see the force of that criticism. I know that there are still jurisdiction proceedings and claims.
Those are only the two that signed the
So there are other jurisdiction issues.
No.
My client has raised it as well.
Yes, your
Yes.
client was raised, but
What I am saying is that I can see the force of arguments ranged against the jurisdiction.
What Sir Jeremy has said in this? What Sir Jeremy has said in this?
Yeah.
What he have said?
Well, he says that the guarantee has a clear dispute resolution clause which gives these courts jurisdiction. And he therefore sees that it is extremely difficult. I can't remember his precise words. I don't think he rejects it out of hand, but he says it's extremely difficult to mount a jurisdiction on. Now, I have read that, and what I can say to this court is that it is not in the fourth defendant's interest to pursue a bad point. Because of my recent involvement in the matter, I am not prepared to jettison it without proper reflection. And in my submission, one can leave the jurisdiction point to one side for present purposes, because in my submission, the need for hearing in relation to the forgery claim and the convenience of all matters being dealt with together.
You are not withdrawing, but you are not going forcefully on this point.
Your Honour has the point.
Okay.
So, that is in essence what we say, and may I just pray on the court's time just to take you through very quickly my skeleton argument, which I've largely covered already, but it may be of help just to see how I formulated some of the arguments in writing, perhaps more concisely than I've been able to do earlier. So Your Honour sees that it, in essence, paragraph 1, I say I'm responding to the respondent's skeleton. Paragraph 3 and 4 on page 2, I make the point that this is the substantive hearing, not an application for permission to appeal. Paragraphs 5 and 6, I make the point that the respondent's skeleton is late. It made it difficult for me to deal with it in the time available. I dealt with it. I don't press that point further. Then we go over to the third page, paragraph 8, where you can see that the respondent has considered the appellant's grounds of appeal under 4 headings and has directed its attention at the first leg of Rule 44.19, which of course carries over back to Rule 24, as we've seen. They've directed their attack at whether there's a real prospect of success, whereas the learned judge in the order granting permission focused on compelling reason. Now, it's perhaps difficult to disinter one from the other. We say both limbs are satisfied, and therefore, in order to do that, I've taken the respondent's skeleton, beginning at paragraph 12 of my skeleton, bottom of page 3, and I first of all taken the court to what I described as the Abu Adas case, which is the judgment of Sir Jeremy Cook, which was made on the 11th of June and is appended to my learned friend's skeleton article. It was an odd case because it was an appeal by people who had won. They'd already got what they wanted.
Yeah. Now I remember.
Yeah.
I heard that case.
Yeah.
They wanted to strike off certain obiter dicta.
Exactly.
Okay.
Yeah,
Now I remember.
You're
I did too many things on my head.
and you already gave a supporting judgment, but
Very brief.
respect to Your Honour, it's very much a supporting judgment of what Sir Jeremy Cook says, and the substance is set out in a more extensive consideration by Sir Jeremy. But the point that I make essentially in paragraph 17 of the skeleton argument is to go to what Sir Jeremy was saying. And he said, at paragraph 2 of the judgment, each of the two defendants, that's D2 and D3, each of the two defendants is now in a position fully to defend the claim made against them under guarantees given by them in respect of the indebtedness of the first defendant to its lending bank, the claimant. Now, of course, one needs to interpose the word allegedly given by them. But D2 and D3 have, as Sir Jeremy says, the right fully to defend themselves. All that I am seeking on behalf of my client is an equal right to defend himself.
If there is a defense, there is defensible, possible that he may succeed. How possible is possible? How probable is that probability that he will succeed?
Well, there have been all sorts of words, not fanciful. How arguable is arguable, and Your Honour, Your Honour's an expert. How long
let's apply to these facts of yours.
Yes.
The facts of yours, it says, I didn't sign. The only possibility is that possibility, probable, not perhaps not even probable. Well, he would know. He would know whether there is a probability or possibility of the of the handwriting expert coming to say that it's a forgery or not forgery. He would know. Only he knows he signed. I didn't sign. You didn't sign. Nobody else signs. And perhaps the witness who signs it will know whether it's only a probability, a possibility, or none. Zero.
Well, there are a number
Now,
of things.
is that the probability with is that not merely fanciful? Is it fanciful, or is it probable, or high prospect of success? I mean, that's what we have to decide. That's how we have to decide.
There is a threshold.
You say yes, the respondent will definitely say no.
Yeah. There is a threshold.
We'll flip a coin and decide. I'm just joking. I'm just joking, please.
Some degree of conviction.
Your Honour is absolutely right. There is a threshold, but it's a low threshold. And the threshold in my submission is satisfied because at the first opportunity,
He has said that.
and he's indicated an intention to seek expert opinion.
At first opportunity, he has said it is forgery.
So, and this is why the chronology is, in my submission, so important. Because one goes back to everything that went before November 2018. My client had no knowledge ever since 2018. He's done, in my submission, he's taken the right steps. Now, one may say, with the benefit of hindsight, with the benefit of common law eyes, etc., some things could have been done better. But he's taken the right steps.
Understood. Yeah, we understand it quite well. Have you finished?
Well, I'm just taking. I was just taking your honours through my second argument. I'll do it very quickly. Paragraph 17 really makes the point. I've read what Sir Jeremy said at paragraph 2 of the judgment, and by parity of reasoning, my client now seeks to have the immediate judgment against him set aside, so that the action might continue. And let me take you to another paragraph in Sir Jeremy's judgment. It's paragraph 37. And the reason why I read it into the record is because there's a typographical error in the learned friend's skeleton argument, where he identifies it as having been paragraph 17. I think we're on common ground. It's paragraph 37 of Sir Jeremy's judgment. Last paragraph. He says, "It appears to me that there's been enough delay in this action already, and that it should now continue following dismissal of the appeals at a much faster rate than heretofore."
Yes.
What he's talking about is the action collectively. And in my submission, that is to be taken of a piece with the passage I just read to the court from paragraph 2, where what was in Sir Jeremy's mind is, in my submission, absolutely clear. And in order for there to be a level playing field, in order for the matter to be dealt with conveniently and expeditiously, in accordance with the overriding objective, in accordance with common sense, the immediate judgment should, in our submission, be set aside, i.e. the appeal should be allowed, so that the whole action can move forward.
Okay.
And then paragraph 18, you have the extract from paragraph 2 of the judgment which I just read. And then turning to the foot of the page, I made the point already made that my client was not a signatory to the facility agreement, only to the guarantee. Going over the page, learned friend's argument relies on A, executed the guarantee, as he said. We put that in. Paragraph 23. The guarantors under the guarantee were served with a notice of default. We put that in. And then we go to the grounds of paragraph 25. The forgery ground is explained in paragraphs 28 and following. I've taken the court back to paragraph 53 of the Schedule of Reasons by His Excellency Justice Omar Al-Mahari. That was part of the discussion and our submission that either it wasn't sufficiently pointed out to the learned judge or he overlooked the effect of the evidence back in 30th of November 2018 of the statement. Those points are clearly summarised in paragraph 30 of our witness statement, so that we are at the moment, and I accept there will be evidence put against my client in relation to the forgery. That will be at the heart of the trial, I have no doubt. But at the moment, my client's evidence is not contradicted.
Okay.
And just as it's not appropriate for the court to make a finding inconsistent with the evidence before it, as Jeremy said, nor is it here, and I've given you the reference to the Almaazmi matter there. Then, going over the page, pages 6 to 7, is the extract from paragraph 46 of the Statement of Reasons, Schedule of Reasons, which is, well, what is the evidence you can reasonably anticipate at trial? The expert evidence point is elaborated in paragraph 34. And then in paragraph 35, I draw the strands together. In our submission, having done that exercise, it is clear that the appellant or defendant's case is more than merely arguable, that it does carry conviction, certain degree of conviction being the very words that one must apply, for the reasons that I've indicated. And therefore the criteria for immediate judgment, and shutting my client out totally from here on in, other than satellite litigation with regard to indemnities, contributions and whatever, criteria for immediate judgment is not met. Then going on to page 8, at paragraph 37, I deal with the date of knowledge point. And then I said I would take Your Honour to the point about blanket liability. If Your Honour looks at paragraph 40 of my skeleton, I refer to the passage in the Learned Friend skeleton, paragraphs 20 to 21, where he makes it. And I say a release from any liabilities is a general blanket release. It's a shorthand means to release from such liabilities, if any. And it's simply impossible, we say, to spell out, as the respondent seeks to do, awareness of a specific liability from such unparticularised work. Then, Your Honour, for reasons of economy of time, I won't read in detail what I've said about the other limbs, about the applicability of clause 1092, about the importance of the minority shareholding, and about the jurisdiction claim. But I do, at the end of our skeleton, raise a further consideration, and this really comes back to some other compelling reason. It's a point I've already covered, but it's there in paragraph 51.1. 6 defendants, 5 guarantors, 2 we know from Sir Jeremy's judgment can proceed to the full hearing and full defence. We ask on behalf of the full defendant that should be the case. In what is by any view complex, interrelated arguments which involve serious, disputed, factual allegations. And on that basis, we say the action has an integrity, it has a totality. And then I draw attention to the chronology, which we've already had the benefit of going through. And I say that if there's been any delay, actually, the delay is on the part of the claimant in bringing serial applications for default judgments, which have been refused, and now in pursuing an immediate judgment application, when really there are clearly serious factual allegations which should be put before a court, lock, stock and barrel, properly pleaded, with proper evidence, and that's where we need to be going.
Okay.
So, the
That's it? Thank you very much. Thank you.
I can help you.
Before you sit down, there are a few questions I want to pose to you. Who was the first party who prepared the loan facilities and guarantee documents? Was it prepared by solicitors?
The facility agreement and the guarantee. I can't speak directly, My learned friend may be able to help because one might expect that it's...
You're your solicitor. You paid him to go through the documents. Who prepared the documents? Who prepared the loan documents? Who prepared the facility agreement?
But the signature is forged. They should know what it suggests.
Huh?
He said one signature is forged. I know nothing about the document.
No. I want to know who prepared the documents. Was it prepared by the lawyer? Okay, they do not know. Okay, never mind. That's one. Secondly, who attested? You do not know also. Was there any police report made by your client to say that somebody forged my signature?
Okay.
Was there a...
Police report.
Complaint.
Police complaint made.
not as far as I'm aware.
No, because we wanted approval from the court.
No. What the Chief Justice is saying, you discover somebody forged your client's signature. Have you made any criminal case in the Dubai police saying that somebody forged my signature? This is what he was asking. No.
And then the next thing, who was it who waived the liability? You mentioned just now about his liability being waived. Who was it who waived that liability? You mentioned in your submission, I forgot.
And it's the second and third defendants, or it might be the first and second defendants.
Second and third defendant.
Well, let me take you back to...
You mentioned that in your submission.
Passage that I'm relying on. I want to make sure that I rely on...
The witness statement. The witness statement.
It's in the second witness statement.
Yes.
It's document 5, I think,
Yeah.
in your bundle.
What did he say?
Second witness statement, second page, under paragraph
the first and second defendant had expressly released me. The first and second defendant had expressly. So it is the defendant.
Yes.
Is it possible for a defendant to release the liability of another defendant?
I fully accept that it's the defendants inter se who made this release, and that's why I say that the minority shareholding element is important, because for a principal natural person, the principal natural person behind Fast Telecom, to themselves release.
So you admit the defendant cannot legally release another defendant's liability. Only the lender can do that.
Of course.
That's
and I'm not suggesting
that's first question.
Yeah.
The second question is when you talk about release, there must first be a liability before it is released. Right? Logically, normally speaking. There must be a liability. I release you from that liability. How did he become liable in the first instance if he had not signed the document?
Well, may I take you on back to paragraph 40 of the skeleton, because that in 4 lines, I hope, provides an answer to Your Honour's point.
I'm being fair. I'm putting to you all that is floating in my mind.
Your Honour, it's important that I have an opportunity to answer the point by taking Your Honour back to paragraph 40.
40 of
my skeleton.
Okay, your skeleton.
Page 8.
Indeed, page 8.
Yes.
Reading from the second sentence, a release from any liabilities is a general blanket release. It's a shorthand means to release from such liabilities, if any. It's simply impossible in our submission to spell out, as the respondent seeks to do, awareness of a specific liability from such unparticularized wording.
Now, can I ask, so this release took which type of form, like a document, or how that release became visible? That release. How your client being released on agreement or which basis?
I can't assist the court as to whether there is a formal document. I simply don't know as to whether there is a
So
formal
it's like
document.
word of mouth, then somebody, his shareholder say to him, you are released from any liability against us, then he thought he's not being released?
Well, this is pure conjecture, so bear with me and maybe conjecture.
No, because you put it in your skeleton argument, and you have to...
No, sorry, my response, what I'm about to say is conjectural, so bear with me in that regard.
Yeah.
We know that the fourth defendant is very much a minority shareholder. I know you don't have to...
I don't know because I don't... Look, you say you know. We don't know because we don't see that agreement.
No.
Unfortunately, you submit this appeal without even a facility agreement and there's a guarantee agreement. I don't see it.
Well, we try to keep it to the minimum.
What do you mean by minimum? This is a very important document. I don't have it here. Did you submit it in this appeal?
And this is always the difficulty. You keep
No.
it minimal and something is necessary.
I'm trying to help each other.
Yes.
To help you. We keep talking about the facility agreement and the guarantee agreement has not been signed by your client, and I don't see this agreement in this file. Plus now you're saying that your client being released from any liability, and that release is not taking any form of document.
Well,
So this is the confusion we get.
well, Your Honour, can I deal with it in this way? And this is the best I can do. We do know that my client was a minority shareholder. That isn't within the facility agreement, isn't within the guarantee, isn't within anything. He simply had 3% of the company. We know from the chronology that he didn't have day-to-day involvement with anything to do with these matters because he didn't know about things for more than a year. So we see someone who has a minority interest, and it looks very much like a residual minority interest. He's moved on, everyone else has moved on, he just happens to have a shareholding, and that's it. So in that context, if people have done that, it is perfectly reasonable for a company and its principal director to say, okay, well, you don't have any liabilities in relation to Fast
There is any direction has been issued by the company, like a shareholder direction?
We don't have a shareholder register.
So I have to say, I have to believe what you are saying just by word?
Well,
I need to see some evidence.
Well, the evidence that we do have, Your Honour, is the chronology.
Acknowledge is not an evidence. I need to see a document saying that your client has a only 3%. I don't have it in my file. And I don't have that declaration from other defense saying that you are released from any liability. This is what I'm trying to find.
Your Honour, I do understand, but in my submission, what we're looking at is a question of immediate judgment. And one of the requirements in relation to immediate judgment is that the court shouldn't enter into a mini trial.
Right.
And the risk is
Yes.
that we enter into a mini trial. And what we have here is the fourth defendant's evidence, supported by a statement of truth.
His own statement.
Where he says, he's already said that he's a minority shareholder. He said that in paragraph 6. By way of background, I'm a very minor shareholder. So we have that evidence confirmed by a statement of truth. We have the
I
chronology.
think Mr. Bostani can confirm that fact. He's a minor, doesn't he? Sure, please.
Yeah, just before you move.
Yes.
The lower court gives the four defendants opportunity to submit any evidence. And the only evidence submitted so far is witness statement by saying, I haven't seen this document, I didn't sign this document. You don't think it would be much proper for the defendant to submit any document show that the difference between his original official signature and the signature appear in the document? At least to convince this court, in the face of it, it's a big, huge difference between both signatures. Before we believe that we have to send it to the Dubai police.
Well, Your Honour, We're in a legal.
No. I'm talking about the first opportunity you've been given by the lower court when they discussing the default judgment set-aside application. And they give you the 14 days to serve and file evidence. And there is no any copy of the official signature of the defendant who's alleging that forged the signature by saying, look, this is my passport, this is my national ID, this is my signature. It's far away from the signature appear in that agreement.
Your Honor, I hear what Your Honor says, and I understand exactly the point Your Honor is making.
Yes.
There is, however...
See, until today, I don't have that before mine.
No, but Your Honor, the answer in my submission to Your Honor's point is that we are in a court conundrum or bind. We're in a difficulty. And we're in a difficulty because I've had personal experience of submitting to a judge, well, look at the signature on page 27, and look at the signature on page 53. And surely Your Honour or Your Lordship can see that it's a different signature, but it's purported to be by the same person. And the judge then turns around to me and says, where is your expert evidence? I'm not accepting your hearsay. So, on that basis, I can't venture down the route that Your Honour is inviting me to do, because I would be met with that response.
I think that what my learned friend was saying is your client did not even attempt to do it.
Well,
because his conclusion, I'm saying, is not important. He's saying that if your client sincerely, honestly believes the signature is not his, he will produce to his lawyer, or his lawyer will have asked him, a good lawyer, will have asked him, show me your samples of the previous signature. And you just photocopy, present it before the court and say, look, this is my genuine signature, this particular one is not. Of course the court can reject, the court can mimic. But you know the English law, the decision of opinion is made by the judge. The opinion given by experts is merely to assist the court in making a decision.
And it is the evidence of an expert,
Yes.
and not the evidence of counsel.
Yes,
So
yes,
it's because it's not the evidence of counsel that, with respect to the point which is being put to me, that is, in my submission, an answer to that point. But then we have the related point, which is the difference between the common law approach of obtaining independent evidence and the civilian and particularly juvenile approach of that evidence being the exclusive reserve of the police laboratory.
Well, Mr. Michael, excuse me for this. Well, I appreciate the point that you was not the trial advocate then. I appreciate this, I understand. You were not present then. And the trial might be conducted by a civil law lawyer or something. But for your defense to carry some degree of conviction, then you gotta support it with something. You can't just say, oh, it's forged. Full stop. Nothing in support. No, I understand. It's your statement is your defense. Understand this. You said, that's what Justice Shamlan trying to say. For your defense to carry some degree of conviction, it has to be supported by certain elements. It's not about civil law system or common law system. You need to convince the judge there is some degree of conviction. The immediate judgment application must not be granted because...
Yes, and may I address that point?
Yes,
exactly. Because you'll recall that in one of his few interventions, Mr. Bashara, today in the body of this court, said that there had been no criminal complaint because he, on behalf of his client, had been seeking the reference of the evidence to the laboratory. Now, I accept from in a common law context that that's not the right way of going about it. Mr. Bashar's concern is, well, look, the laboratory will only work on the basis of an original document. We don't have any document, and what we've got has been provided during the course of the proceedings and has been copied on. The original of that document must reside with the bank, and therefore my other friend's concern has been accessing the original document necessary under civilian law for that investigation to take place. And he was saying that there has been no criminal complaint for that reason.
But
Now,
if he want to make a criminal complaint against the bank, he will approach the Dubai police, and the Dubai police will communicate with the bank to send them the original document. There is no need for this court to get interfered. But just 1 second. When you are saying this court at least has to adopt the civil procedure because it's international court, I understand that. But for the civil judge sitting in Dubai court to make that certain or believe he has to do so, you have to show him that there is a big difference between his official signature and the signature already there in the document. Otherwise, the judge will not release anything. How come?
well, collectively,
If you want to take that civil procedure, you have to take it as a package.
collectively we are pulling in the same direction. We all want that evidence, and I accept that evidence is not yet available.
You don't have a copy of the guarantee agreement?
Not
Of course you have.
not in the bundle.
How come? In the first, the main claim, and when you make your default application for set aside, it should be in the bundle.
Your Honor, when you approach the police for a forgery case, they will ask if there is any court claim in this respect. And when you say yes, there is court, they will not accept any claimant, but they will tell you to go and apply the same at the concerned court, which should notify the police or the relevant authority in this respect. And regarding the signature, we have the client signature on the first witness and the second witness statement, which is different from the signature on the guarantee.
I don't see it. I don't see the guarantee. I don't have it in my file. You submit an appeal file, that's useless. There is no enough document. This is what we are saying.
This in the file, and the claimant was then provide the original and send it directly to.
No, this is.
Sorry, Your Honor,
I think we have had enough of this. Huh? I think no more question. Any more questions? I think we'll hear the Mr. Bostan.
Thank you.
I think we are going in circles.
No, one point is very important from what Mulla and friend has just said, and that is that the Dubai police, once they know that there are court proceedings, they will ask, the first question the Dubai police will ask, as I understand it, is, are there court proceedings? That question has to be answered yes, because there are. If there are court proceedings, then the policy of the procedure of the Dubai police is to say, right, we won't touch it because there are court proceedings. And yet we can't come to this court in the way that we can go to the onshore to get the necessary order. And that is the bind that we have found ourselves in. And it's impossible to cut that knot. And that's why we don't have. And I would love to be in a position of saying, yes, we've got this expert evidence and that. But that's why, procedurally, we've been locked off at each stage. That's all that I would say, and I'm grateful for being able to say.
We'll take a short break, 10-15 minutes, come back at 12:15. How long do you think will take, Mr. Bostan?
Not long, Your Honor.
Short?
Short and
Direct to
sweet.
the point?
Right to the
Don't
point.
say things which are irrelevant?
Absolutely not.
Don't repeat?
No.
Okay, we'll take 15 minutes. But thank you very much.
All rise.
Sorry.
12:25 now, Mr. Bostani.
Yes.
We think you should just go on the forgery issue.
Yeah, we'll go
Only on the forgery.
Only on the forgery issue, Your Honor. I will make a small introduction, Your Honor, and then we'll go straight on the forgery issue.
And important, if you can assist us,
Yes.
is when we talk about prospect of success, what is that threshold insofar as this particular case is concerned.
Absolutely.
It's easier said than done, you know. That's where the judges, very difficult.
Yes, yes, but I believe the prospect of success, Your Honor, should be supported by evidence.
Okay, just go on.
Your Honor, I believe we should be, first of all, grateful for Mr. Patrick Joyce for this romantic vision that he had for the DIFC court that could be a kind of fusion between a civil law jurisdiction and the common law jurisdiction. However, unfortunately, this is a deep misunderstanding of both the purpose of this court and its rule and of the civil law system. And before dwelling into the forgery point, I would like to say that contrary to what Mr. Patrick Joyce is saying, there is indeed more than a level playing field in this particular case.
More than?
A level playing field because...
more than a level playing field.
Yes, because Mr. Mazrouei is not in the same position as Mr. Abu Adas and Mr. Barghouti. Mr. Mazrouei had the opportunity to present his defense, and he did in fact present his defense and submitted his defense and did not raise in his defense the forgery case.
This particular forgery.
Yeah, absolutely. Before Judge Omar al-Mahid
did not raise in this defense. Okay?
Yes, while the two others were given by Justice Cook and by Your Honor and by the court, in fact, the opportunity for the case to proceed. However, they did not submit their defense to this day. They are still arguing about the jurisdictional challenge, while Mr. Mazrouei did have and did submit his defense. Therefore, the argument about a level playing field does not stand at all in this particular case.
Who is the person? What defendant is he? The one you're mentioning, the name you're mentioning just now.
Mr. Mazrouei is the first.
Mazrouei is here.
And the other two are Mr. Abu Adas and Mr. Barghouti.
Yes.
The two in which Your Honor and Sir Jeremy Cook and His Honor Mr. Madhani has issued. They are still at the jurisdictional challenge.
Yes. And the third one?
The fourth one is Mr. Hormoudi, for which you issued an appeal rejecting his case. And that raised the forgery argument as well. Very important.
He didn't raise, he made a statement full stop.
No, he raised it, and Ms. Wright mentioned.
Ms. Wright mentioned.
In her statement of case and before the court that there was indeed, and this comes to my point, that in the civil law jurisdiction, when you argue forgery, you go straight away to either the police or to the public prosecutor to say that my signature was forged. And in this particular case as well.
Ms. Wright's case, the one that we dismissed,
yes.
What number, what's the defendant number?
Ms. Wright's case, Mr. Hormoudi, was the fifth
defendant.
Yeah.
Can you
there are some differences because Mr. Hormoudi has never gone through immediate judgment application. They were tackling default judgment only, is that right?
Only
two default judgments.
Yes.
And one of the reasons given, it's abuse of process.
Absolutely.
You have no...
Yes.
And so there is a lot of differences between that case and this case.
Yes, but what I was alluding
so
to...
it's not denied only because forgery was raised for the first time before Court of Appeal.
True.
So
and in this
case, they're saying it was raised 8 months ago in a statement of case and before trial judge.
The statement of defense, it was never raised.
I said no, it's witness statement.
Witness statement, true. But even in the witness statement, it was not clearly mentioned. It says a guarantee that purports to bear my signature. It doesn't mention the word forgery, and this is important to note. So even the witness statement is ambiguous and is not clear around. So this is. Go on. I will go on.
Yeah.
So, secondly, and to the point, it is very important to note that when a shareholder, first of all, in corporate law, a shareholder is never liable for the debt of the company unless he has given a personal guarantee. So when the fourth defendant, Mr. Mazrouei, raises the issue of waiver of liabilities, then there must be a liability somewhere. The shareholder is never liable because the shareholder is only liable up to his contribution to a company. So if a company goes bankrupt, he loses his 3%, but he's not liable to the lenders of the company. This is never the case. So in this particular case, when Mr. Mazrouei mentions that he is waived of his liability, then there must have been a document or something that he has signed that binds him to something. Otherwise, why would he be waived of his liability?
Yeah, but these are lay people. Lay people. If my friend, I owe money, and then my learned friend here, Mr. Ali, says, Zaki,
No, but
your what do you call? Your debt is waived.
yes, but
I will accept it is waived. Huh?
I'm a shareholder. I'm a 3% shareholder. Why would I have any liability? I shouldn't have, unless I have signed a document which is the guarantee itself.
Okay.
Further, another argument, Your Honor, is the raised by the first defendant of Article 1092 of the Civil Code.
That one, I don't think he's serious about it, huh?
No, he's not serious, but why would you raise Article 1092 of the Civil Code? Article 1092 of the Civil Code is in relation to the 6 months period for claiming a guarantee. So if a lender does not claim a guarantee within a 6 months period of the debt being due, then this guarantor is waived of his liability. Why would I mention it if I'm not a signatory to a guarantee? And this is all in the statement of defense of the first defendant, Your Honor.
You are saying that if he doesn't sign, he doesn't sign. Full stop. Don't have to talk about any other issues. That's what you're saying.
No,
If the defendant says I didn't sign, full stop.
Absolutely.
Other issues are irrelevant.
Are irrelevant. Not only I would not talk about any other issue. I would go straight away to the police and to the public prosecutor. Besides, who is the alleged forger of this guarantee? Nowhere it is mentioned in any document, in any statement. Is it the company? Is it the bank? Is it?
No, the first witness statement has been mentioned. In the first witness statement was mentioned that the fourth defendant, he mentioned that this is not his signature.
Yes,
Paragraph 6.
He does not mention the word forgery. He says purports to bear my signature. A document that purports to bear my signature. But he doesn't say who is accused or suspected of having forged his signature. Is it his shareholders, his other shareholders? Is it Mr. Abu Adas, Mr. Barghouti? Is it the bank that is accused of having forged his signature? Nowhere it is mentioned. That's why we believe that this whole argument has only been made up. And to go back to the chronology, I totally dispute the fact that the fourth defendant has only become aware of the proceedings on November 2018, because the proceedings have been going on since July 2017. We have served all the defendants at their home addresses mentioned in the facility agreement.
Yes. But the fourth defendant came to know about it. When did he first come to know about this suit against him?
Investigation.
Enforcement.
Only at enforcement
Yes,
Dubai
okay.
court.
Let's assume I want to go by this argument. First, as you know, Your Honor, any default judgment is published on the DIFC court's website. And this particular judgment was
He is a layperson.
But this
He's a layperson. I know people who have been declared a bankrupt. He didn't know until the bailiff came to his house to raid. Then when he say, I never knew I was a bankrupt.
These are the rules.
There is I need rules.
You cannot raise set aside in England. I believe it's 1 month considered as reasonable to file a set aside application, because under the IC court there are no time limits.
You must have knowledge of that which you're seeking to set aside before you can apply to set it aside.
Yeah, but it must be filed within a reasonable time period.
A
And
reasonable
secondly-
time from the time you found out.
And secondly, Your Honor, the
No, do you
enforcement-
agree as a fact that the fourth defendant only came to know about the case or the claim against him when Dubai court wanted to enforce it
No,
against him? Do you accept that as a fact?
I don't accept that.
You don't. So what is your contention? When did he first come to know about it?
When we served at their home addresses to the sixth defendant.
Then why do you set aside?
Uh-huh.
Why do you reserve? Why do you reserve? Why was it set aside and reserved?
What was it set aside? Because they came to argue that the law firm, because Your Honor.
No. As a matter of fact,
Yes.
for this court,
Yes.
we have to conclude that he came to know only after the Dubai court went after him.
The Dubai courts, the enforcement proceedings at the Dubai court started in May 2018.
Yeah. From there, he came to know about it. That's when he first came to know about it.
It would be
Because I cannot. You are alleging he knew from the beginning, but we have to accept that he knew only after that, because otherwise the court would not have set aside the judgment, the default judgment.
This particular point was touched upon in your judgment,
Yes.
Sir Jeremy Cook's judgment, that considered that in fact the default judgment was validly entered and was within the time limits, and the subsequent set aside should not have been entered into, but now they have been entered into.
But these are different people. Yes, you rightly say. Each defendant has his
Yes,
own
but-
facts.
But they have
You know,
raised the
at
same,
different
the same
facts.
arguments.
We cannot use the facts in one case to decide the facts of another case.
No.
Okay, go back to the forgery issue.
So,
Tell us on the facts of this case. Facts, not the facts of this case. Is there a likelihood of the appellant succeeding at trial should we decide to allow the appeal?
Your Honor.
That is the crux of the question. That is what is going in my
At the
mind.
facts of the case, we have a signed guarantee.
Yes, some
That-
guarantee.
That says that the person is bound by any and all liabilities.
No. Don't read the document.
No, I'm not
Mr.
reading the
Mr.
document.
Bustani, look at look at his signature. Look at his signature. The question is whether he signed this piece of paper. That is the question. Don't worry about the contents. Did he sign this paper or
I'm
not?
convinced that he signed this paper, yes, Your Honor.
Huh?
I was not there, but
I know. Nobody of none of us is here.
But he has-
None of us are here.
has-
But in law,
Yes.
in law,
He is bound by his signature.
prima facie, you are saying he should be bound by this document.
course, unless-
If he says he doesn't sign,
He needs to
then
bring
he
in-
has to prove it.
He needs
That is true. But the question is, when should he start proving that it is not his?
He should have
Now or at trial?
I said it, Your Honor. I said it when you know that, or when you allege a forgery, you run. If you were assisted by civil law lawyers, you should have run to the police or to the public prosecutor to say that I'm bound by $15 million. It's not a small amount. I did not sign this document. I filed a criminal complaint for forgery against X. Please investigate. Then the police would have asked him, where is the original? He would have told them, I assume that the original is with the bank, if he had not signed it. The police would have called the bank and said, give us the original, and would have sent it to the lab. And if we were in a common law context, as my friend was alluding to, then there are a number, not small shops that are emerging, which is not an accurate description. You have the likes of Deloitte that do forensic testing.
You are saying that there are private people who can do forensic testing.
And major corporations like Deloitte, like Navarro, and we use a lot of them by our law firm. So there were plenty of opportunities for the first defendant to bring and substantiate his case forward, which he did not do at all. And my contention is that the fourth defendant did not meet the test of 44-117 to argue that the court of the first defendant of the first instance was wrong or unjust because of proceedings. He had the full opportunity to submit his case. He did not do it. And as you know, Your Honor, Sir Jeremico and your court have decided that this case should proceed at a much faster pace. Unfortunately, we are still somehow stuck in limbo because we are not able to enforce on the obligors. Therefore, I would ask the court to reject the case and our full costs for the appeal.
Any question?
Yeah. Maybe perhaps you can give us idea, what is the formality, if you know, because
Yes.
formality of taking a signature from a guarantor, sorry.
The formality.
What is the formality?
There are no specific formalities in law, but the person should come. I assume the person would come to the bank, and in this particular case,
Came to the office in DIFC?
Came to the office and signed it. In this particular case, the facility agreement was entered into 22 December 2015.
Yes.
And so signed by Mr. Abu Adas and Mr. Barghouti as manager of the company, and they signed separately the guarantees, the personal guarantees. Then 1 year later, in 21 November 2016, they wanted to roll over the loan. The bank has asked, because they haven't paid, they were supposed to pay, they haven't paid anything. The bank has asked for further guarantors, for extra guarantors. And the three persons came forward, Mr. Zahra, Mr. Hamoudi, and Mr. Mazrouei.
And who's this Mr. Shafiq Murad?
He was, Shafiq Murad is the CEO of the bank.
CEO of the
Former
bank.
CEO of Bankmed, yes.
And Lama?
Both are from Bankmed.
Have you so far submitted any evidence from their side?
Yes, we have submitted witnesses' statement, not in this particular case, but in relation to Mr. Barghouti, we have submitted witness statements from Mr. Shafiq.
What did he say, that statement?
It was in relation to arguments by Mr. Barghouti.
Other defendant?
Another defendant, absolutely.
Why you did not find witness statement and reply to the given witness statement in this particular case? This case, there is a statement of someone saying, I don't think this is my signature. You should have done some.
Your Honor, this witness statement was not filed in this particular case. It was filed, if it was filed in support of the set-aside application. Then the hearing, then we moved to the hearing and a statement of defense. Once the set-aside application was granted, the defendant was given 14 days to reply, and he had to submit his statement of defense. And in his statement of defense, he did not argue the forgery case.
And he did not refer to his witness statement as well?
Not to my knowledge.
And it was not brought to the trial, the witness statement?
The witness statement was not brought to the trial. Mr. Bshara,
Not part of the bundle?
in the hearing itself, said that his client did not sign or say that.
This witness statement of November 2018 was not part of the hearing bundle?
There was no hearing.
Are you sure? No hearing bundle?
No hearing.
How the immediate judgment application was heard without a bundle? There must be a bundle.
There must be. But we did not, it was to the...
It's either you didn't know or...
No, we yes.
You didn't know?
I don't...
Oh, you don't recall?
I don't...
So you think that witness statement, which is saying that this is not my signature, is not relevant to your immediate judgment application, and this is why you think there is no need to reply to that witness statement? Because you see this is a separate case?
It was not proved in the statement of defense, Your Honor.
There is no reference in that statement of defense for
Not
his
at
first witness statement?
No.
Well, you know, the court can refer to any statement by the defendant, either in his official defense or in his witness statement. Because witness statement is part of the defendant's statement itself.
Your Honor, I believe this is not a serious allegation. This is unsubstantiated. This is his own words, his own allegations, his own claims.
Yeah, but for the purpose for today's hearing, you should submit kind of reply to the evidence that has been submitted, and the second witness statement of the applicant. It's an evidence, so at least you have to reply to that by having your own witness saying, no, this is a signature, a true signature, because I am so and so took his signature on that day.
In the bank?
This is the normal formality would be? Okay, the second question, this is a personal guarantee. Would it be much proper for have a stamp from the bank itself?
No, this is signed by the...
Because the claimant give $15 million US, and this is a personal guarantee.
Yes.
And only there is a signature and stamp from the other side. No, this is the telecom. Is it First Telecom the bank?
No.
Bankmed, Fast Telecom is the
From
bank.
Fast Telecom.
Fast Telecom is the
From
bank.
Fast
Yeah,
Telecom.
this is what I'm saying. This
Yes.
is the personal guarantee has no any stamp from your client. You think
No
it's no need?
witness. Well, my
No
little
witness,
friend,
no
no
There is no
witness.
requirements under the law, Your Honor.
I'm just asking the practice to give it more valid. No?
But this
So a person who borrows money can just sign a document without the requirement of a witness. That's what you're saying?
No, what I'm saying, Your Honor, this is a guarantee that was signed by Mr. Mazrouei
Yes.
and was witnessed by the authorized signatory of the bank, which is Mr. Shafiq Murad, former
those-
CEO.
Those two are the witnesses.
Yes. Former
They
CEO.
are not the parties to the action, the parties to the transaction.
No, this is...
They represent the bank.
They
The bank
represent the
staff.
bank.
Yeah,
They
the
represent the bank. So Mr. Shafiq Murad was former CEO of the bank.
So they were in fact attested by.
And Mr. Lana Al-Qaisi is the trade finance officer of the bank. And it is
But it's...
witnessed by Fast Telecom, and it is signed by Mr. Al-Mazrouei.
But there is no statement next to the bank officer saying that this document signed before them. It doesn't say that.
I mean, it is
This
addressed,
really
it is addressed to the bank. It is addressed to the bank.
But
It
what
is
if,
addressed to the bank.
what
And
if
it's
the bank
sent-
signed it and they
No, no,
send
it
it
is
to someone
sent
in the
for
company?
and on behalf of Bankmed SRL,
Okay, giving to the
trading in the DIFC under the
Yes.
trade name Bankmed Dubai, name
document-
Lamal Qaisi, trade finance officer, Shafiq Murad.
yes.
It is addressed to the bank and it is signed by the bank for and
Now,
on
can
behalf of
I ask you one more thing? After you're receiving this the guarantee, did you accept that by any form rather than those signatures? Did the bank send a letter say, "Oh, this guarantee is accepted"? Send it to the company who took the money, or no such of these things. So you receive those, you accept those letter from the company, and there is signature of guarantee. So after that, the bank would communicate with the first defendant and say, "Oh, I accept those guarantees."
Yeah, absolutely. Because I assume what happened, as I said, there was a rollover because the borrower did not pay any amount. So the bank wanted more guarantors to guarantee itself.
Yes.
And those three were not covered by the first and second defendant.
And this letter is enough for the
Yes,
bank
this is a
to
guarantee
proceed.
under the form of the DIFC that is governed by the DIFC. We practice it normally. This is a form of guarantee, and we give opinions on such guarantees. We believe that this is valid.
But do you ask for any personal document from the guarantor?
Yeah, I would assume they would have their identity cards and all the rest, of course. And we have asked for their addresses. Now they are claiming that this is not their addresses, but
Yeah, but the criteria that we have to determine here again, I repeat, is whether the appellant have crossed the threshold of persuading us that
I believe
there is a prospect
I believe
of them succeeding if the case goes for trial.
Your Honor, I believe it should not, because it is totally unsubstantiated, unevidenced, alleged.
Because otherwise everybody will come and say it's not my signature. It's not my signature. Everybody can come and say it's not my signature. Their only defense is, the only point that is in their favor is that, for me, I'm speaking for myself, I'm not speaking for my learned friend, is that he made that statement as soon as he discovered that there was
Again,
something.
this is unsubstantiated that he learned only on November 2018.
Well, the sequence of events seem to show
Why?
the sequence of events.
No,
It was set aside, he put in straight away. How?
I don't believe so, Your Honor.
How? Show me.
Because, Your Honor, the case started in...
No.
I will tell you.
Those cases are irrelevant. The fact that it was set aside.
Yes.
Okay, what is the ground of it being set aside?
Because it was set aside for all the defendants, because the court considered that it would be fair and in the objective of the...
They were set aside because the defendant was not aware there was a suit against them. Or there was a claim against them. That's why it was set aside.
I'm sure, Mr. Hormoudi filed his first set aside on 13 November 2017. Haven't they spoken?
Wait. Mr. Harmoudi? Harmoudi is somebody else.
No.
Can you show us do you have any copy of that application to set aside, or what the reason for set aside
We have the...
of Mr. Saif?
Mr. Harmoudi's application to set aside was filed.
submitted on 13 November 2017. Yeah,
On
different,
13th?
but I'm sure they would have been speaking with each other.
13th November.
2017, Your Honor.
You are therefore saying that because Mr. Harmoudi was aware that there was a suit against him, a claim against him, that the other guarantors should also be aware.
Because they have been speaking between each other, Your Honor.
How do you know they were speaking to each other? How do you know? There's no evidence they were speaking to each other. I'm being very strict on the law, and I'm just applying the law. That's all.
I totally agree.
Do we have the court decision of set aside the default judgment against the fourth defendant?
Against
Yeah, we keep focus
It's
on
not one
this.
decision.
Huh?
It's different decisions.
No, I want to see the court, what the court say, the set aside order has been, the default judgment has been set aside for,
There are four different orders.
I know, for the fourth, what was the reason?
I have it here.
For not being served, probably, or for what?
Let him answer. It was the wrong address, one, and then BSA went and admitted, filed a certificate
They
of,
accepted service wrongly.
no, acknowledged service. Acknowledged service wrong.
Application or judgment?
No, this is application to set aside the default judgment of Judge Nasser. Is granted, but for what? I don't know.
Yeah.
No reason.
No reason.
That's right, Mr. Michael said there was no reason given, it was just
There
set
is no reason
aside.
to set aside.
He said it was just set aside, no reasons given. He said so.
But
But the
Mr.
argument,
Michael maybe has,
if I remember correctly, the relevant was he was served on the wrong address,
Yes.
and then the lawyers went and acknowledged receipts. True,
it's for different.
isn't it?
No, for the fifth.
All the five, isn't it? All the five. Okay. Anything else?
If you want me to touch on any other point, the jurisdictional point, or
Can you guide us in law? Law, I'm talking about, we have been discussing a lot of facts now. In law, Mr. Michael did mention about what are the the terms used when application to set aside is granted, you cross the threshold, what is the, maybe I would like to, as a reply, can you take that? Mr.
No, I can certainly help the court when I reply, yes.
Yes. Anything else, Mr.
the jurisdictional point, any other point you want to discuss?
We don't think it's relevant for our decision. Yes, Mr.
The court now has available the guarantee, which was not, I apologise, in the appeal fund. The court has now seen that there is no stamp by the bank on the guarantee. There is no signature.
But that seems to be the practice.
Correct?
That seems to be the practice.
Have you raised this point earlier?
We may well
Just
want
because I mentioned.
we may well want to investigate this practice, and this may well be some other compelling reason why this immediate judgment should be set aside. There is no stamp by the bank. There is no signature letter or initials on pages 1 and 2 of the guarantee. Learned friend seemed to suggest that the guarantee was witnessed by the bank. It was not. It was signed by the signatories on behalf of the bank. They were not necessarily or at all witnessing anyone else's signature, because there would have been no need for all the parties to have signed at the same time. So for the learned friend to suggest that a signature purporting to be that of my client was witnessed is simply not borne out by the guarantee. Those are additional matters which clearly create a compelling reason why this appeal should be allowed. There are, I'm afraid to say, Your Honours, some other very troubling aspects of the learned friend's submissions. The learned friend submits, indeed he goes further, he disputes that the proceedings were openly known to my client in November 2018. Not only does he dispute it, he was pressed by the court and he then said, my client knew when he was first served on an address, and he knew then. My learned friend is giving evidence. My learned friend should not give evidence. Is there any evidence from the process servers in support of what he said? No.
That is past, that's history, that's not relevant. The fact that it was set aside means there must be a reason why.
If my learned friend then goes on to say, quote, I am convinced he signed that document, my learned friend is again giving evidence. When my learned friend goes on and says, I am sure they would have been speaking to one another about the fifth defendant possibly speaking to the fourth defendant, my learned friend is giving evidence. My learned friend has absolutely no knowledge at all about any of those matters, and it is wrong in principle, fundamentally wrong, for counsel to give evidence about what is pure supposition and what is clearly not accepted and is in dispute. That alone, the way in which this matter has been put by the learned friend, raises a compelling reason as to why this immediate judgment must be set aside. Now, the court asked both counsel about the appropriate text in relation to summary judgment or immediate judgment. And I can certainly make this available to the court, but it may be of assistance if I read into the record, and then I'll provide a photocopy, but I'll read with the learned friend seeing it. It's the judgment of Mr. Justice Beatson, as he then was, in a case called Top Rise Fashions against Knick-Knack Clothing and various other defendants.
Top Rise Fashion.
Top Rise Fashions.
Okay.
And Knick-Knack, two words, N-I-K-N-A-K, Clothing Company Limited. The citation is 2009, EWHC, England and Wales High Court, 1333, Commercial Court. So it's a judgment of Mr. Justice Beatson in the Commercial Court in 2009, and at paragraph 16, under the heading Summary Judgment, the text, the judgment reads as follows. Mr. Drake, who was counsel for the claimant, and Mr. Latimer, who was counsel for the defendants, agreed. So it was, these are agreed submissions. Counsel for the parties agreed that the principles to be applied in deciding whether or not to give summary judgment have been helpfully summarised in the judgment of Mr. Justice Lewison in Federal Republic of Nigeria and Santalina Investment Corporation, 2007, the reference is given, in which Mr. Justice Lewison, as he then was, stated, and this is a citation from the earlier judgment. 1. The court must consider whether the defendant has a realistic as opposed to a fanciful prospect of success.
Okay.
But it's as opposed to fanciful prospect of success. And that's derived from Swain and Hillman. 2. A realistic defence is one that carries some degree of conviction. And that is why, interposing, I say it's a low threshold. That means a defence that is more than merely arguable, ED&F man against Patel. In reaching its conclusion, the court must not conduct a mini-trial, that's point 3. Point 4, this does not mean that the court must take at face value and without analysis everything that a defendant says in his statements before the court. In some cases, it may be clear that there is no real substance in factual assertions made, particularly if contradicted by contemporaneous documents. Now, of course, we have the contemporaneous document of the fourth defendant witness statement in November 2018. However, point 5, in reaching its conclusion, the court must take into account not only the evidence actually placed before it on the application for summary judgment, but also the evidence that can reasonably be expected to be available at trial. Royal Brompton Hospital National Health Trust against Hammond. 6. Although a case may turn out at trial not to be really complicated, it does not follow that it should be decided without the fuller investigation into the facts at trial than is possible or permissible on summary judgment. Thus, the court should hesitate about making a final decision without a trial, even where there is no obvious conflict of fact at the time of the application, where reasonable grounds exist for believing that a fuller investigation into the facts of the case would add to or alter the evidence available to the trial judge and so affect the outcome of the case. Doncaster Pharmaceuticals Group against Bolton Pharmaceutical Company. And 7. Although there is no longer an absolute bar on obtaining summary judgment when fraud is alleged, the fact that a claim is based on fraud is a relevant factor. The risk of a finding of dishonesty may itself provide a compelling reason for allowing a case to proceed to trial, even where the case looks strong on the papers. Wrexham Association Football Club against Crucial Move. And then the judgment goes on to the evidence. So I hope that that provides a useful summary.
Thank you very much.
I've read it in conjunction with my learned friend, and we will provide a full copy of the judgment
Yes, please.
after.
By the way, Mr. Michael, if you're going to do that, can you also provide the cases cited in that judgment? There are a few other cases
Yes,
cited.
the
Might as well.
Swain-
Give me the whole stack. No. All the cases cited in that part, whatever
Yes,
you read just now.
Swain and Wilson, Swain and Hillman,
And all the-
Doncaster
and-
Pharmaceutical,
Yes.
the Wrexham case,
Yes,
all of the cases
Yes,
which
yes,
are
please.
authoritative.
Yes, please.
We will also provide.
Yes, please. Yes, please.
Mr. Bastani, before you go, we'll come back to you, give you a chance. So, Michael, I would like to ask you this. If this court, hypothetically, would grant you this appeal, what is a possible scenario your forgery case would go through? How is it going to proceed it? How long it might take? What kind of consequences, for example, if the forensic evidence found your client is signatory to the guarantee, for example? So, in short, what is your imagination about the future of this court if it's granted?
I'm very grateful for your honour raising that point, because in our submission, clear directions should be given so that the matter can move forward in the way that Sir Jeremy Cook was anticipating in the judgment we've been looking at. Now, somehow we need to cut through this knot in relation to evidence. I'm speaking extemporising,
Yes,
so
okay.
the mature reflection may qualify this, but in my submission, the appropriate route would be for the appeal to be allowed for directions in relation to amendment of the pleadings, because it seems to me that things have moved on substantially from the defence which was put in at short notice at the end of 2018. So the matter should be properly pleaded, and that there should then be directions, and it might help if there's a direction from this court. Well, we're not going to get a direction from this court which is going to be acted on by the police department onshore. I think it has to be through common law process of finding an independent handwriting expert who can provide appropriate evidence in relation to forgery. And that may not even need to be written into a direction, because I can talk to my legal team and say that that is the way that it should be done in this jurisdiction. If we have any difficulty, then there would be an inherent, if not express, liberty to apply, when we could actually come back to the court, possibly at not troubling the full court, but the registrar, and say we're having difficulty getting expert evidence for this reason or that reason. We then know the problem, and we.
How long will you need to do all that?
Not long. In terms of taking proper instructions, I don't know where the fourth defendant is at the moment. Is he in the UAE? Is he in the UAE? He's in the UAE. Well, I'm going to be here until very near the end of the month. And I've got other things to be doing, but I will make time to attend upon a properly constituted client conference and take instructions. And then obviously instructions need to be fed into a formal pleading, so some time needs to be accorded, but 4 weeks for amendment.
I have not made up my mind yet. We have not made up. We're very honest. We are trying to explore ways of how
So just to correct my understanding, you are not asking this court to refer this to the Dubai police anymore?
No. I think that would be inappropriate because that is going to confuse the position. I know of no basis on which this court can, well, forgive me, I look for help all around me. It may be that this court, as a court of the UAE and a court of Dubai, does have status to ask the authority for the evidence that would be commonplace in onshore courts. But I must say, as a matter of first impression, that seems to be an odd way of going about it. And my immediate response is it should be by way of third-party expert instructions on both sides. But I'm happy to
now,
stand
Mr. Michael, is your client aware that if it is in the end proven that it is not a forgery, he is liable to be prosecuted for filing a false statement? That is why in his statement he didn't say it is not my signature. He said purportedly not my signature. He has not made a categorical statement to say this is forged. I have not signed it. He has not made that statement anywhere under oath. Why? Because he knows the risk of him going to jail. I'm putting him in the stand now and swear this is not your signature. Swear by oath. It is found it is not. He will be prosecuted.
I take your honour's point to this extent, that it is clearly important that anyone who gives instructions must be absolutely aware of the implications of the instructions that they give. I have not met the fourth defendant, and I have no knowledge.
You know why I'm asking you this? You know why? I have half a thought in my mind. This is maybe dragging the case.
Well, it will be there.
I'm looking at the law, okay? I'm not making the law. I'm not allowing that to influence me. But Mr. Justice Jeremy did say in this judgment, we want to move this.
We do want to move on. And that point will be made, if the appeal is allowed, that point will be made clearly to the client, and indeed it's read into the transcript and can be viewed on YouTube and he can see it. So he will be in no doubt about that.
We'll make up. Yeah,
Mr. Patrick Joyce, Your Honor, alluded that they want to amend the statement of defense if the appeal is granted. That this is totally, we totally refuse such requests and respectfully request the court to reject it as well. Secondly, in relation to the threshold of the immediate judgment, it was already, I believe the court has already decided on this point. It's in GFH Capital versus David Lawrence by Sir Roger Giles, where he mentions the thresholds for, and it's rather a high threshold and not a very low threshold. Yeah, it's in CFI 004-2017, Your Honor.
Okay.
It's Sir David Steele, Your Honor. I'm sorry.
Okay, if we have finished with all the submission, you are just repeating. Don't repeat.
No.
We have said what you want to say.
No. I'm reviewing everything which the learned friend has said. I think I've commented on everything that he has said.
Yes.
I could draw the points I've already made.
No.
succinctly, but I will spare my breath.
I do not know my learned friend, but my mind is very clear.
Yes.
Where is the threshold? That
Yes.
I'm going to
And
use your authorities, apply to the facts, and arrive at the conclusion. That is in my mind. I don't know what my learned. My habit when I preside a case, is I throw all that is in my mind to the parties, so that the parties cannot say they didn't have an opportunity to change my mind.
Indeed, and it's very helpful because it means that the position can be seen accurately and, I hope, by reference to various paragraphs of the chronology in a sensible and clear way. It's a very sensible way of conducting affairs.
Agenda 230.
We finish it.
No, detention for decision. I'm not here. I want to discuss it.
Are you going to listen to him, or you can be learning?
No, I think we can get listened to. I think the agenda 230, or you want to agenda. Or you want to?
That's the way we're going to get it. Week or Obaid, we have the chance.
You'll be around to the end of the month, did you say?
I'm here or in Abu Dhabi until...
You're Mr. Gotami, you're always around here.
Yeah.
So, I think we reserve our judgment. I will reserve judgment. We'll come back with the decision, most probably a brief decision first, and a final, the long judgment later. But we'll give you a short reason why, whatever it is, and then we give because the long reason we require authorities, blah 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 blah.
And Your Honor, what I will do immediately is to provide a copy of Top Prize with the supporting cases referred to in paragraph 16 that I've read into the court record. And if I may say so, the approach that you're proposing is extremely helpful, because if the appeal were to be allowed with reasons to follow, then I can start to think more fully about directions and even
what we discussed was whether your client can go and get it certified in 2 weeks and come back and say it's forgery. Because now,
I don't think we can do it in 2 weeks.
The other part.
Mr. Madhani, we are not over yet. You are this rope. I'm not a gentleman yet.
I won't take that point. I'll take that point against you.
So, we'll come back with you in the next few days.
Oh,
I won't be around here, but my little friend will either call parties to court, or we may send by email. Is that all right with you?
Yes, I think that it would certainly be through the friends.
Okay. Thank you very much. Thank you very much for all the submission. Thank you. Thank you very much. Court is adjourned.
Yeah.
That's too much hungry. Enjoy the food.
Thank you.
Good. Thank you very much, Hassan.
Thank you.
Indeed, yes, yes.
And